I'm Kristin. This is Michelle Douglas, and I have Phil with me today. We've been really looking forward to speaking to you in this format and wonder if you actually have a blog or a website or any other, social media platform that you could share with us so that others may be able to get in touch with you by that format.
Website address is www.sobel-tenary-economics.
So, can you give us a bit of a rundown? What, as an economic expert in an employment law case, what is your role?
My main role as the economic expert in an employment-related case really is to calculate what we call economic damages and to take into account the fact that, as a result of some incident, and that could be a wrongful termination, a failure to promote, it could be some other sort of discrimination, harassment there, but as a result of some incident, an individual has been harmed, and specifically, they've been harmed by maybe they've lost their job. Maybe they were demoted. Maybe they were passed over for a promotion. They didn't get the bonus there. And my job is to come in and really calculate how they've been harmed, how they've been damaged, and what their lives would have been like but for the incident. So had this incident not occurred, how much money would they have continued to earn? What would their bonus have continued to be going forward, and so on. In addition to just the compensation, the salary, the bonus, and so on, I also take into account all of the fringe benefits. So many people, as part of their compensation, are getting not only a paycheck, but they're receiving health insurance for themselves and for their family. They may be enrolled in a 401k plan and receiving employer matches to the 401k plan. We work on a lot of cases involving police officers and firefighters and municipal employees who also have pension benefits there. So if they are terminated early, then they lose out on various pension benefits. So we really take all that into account, and we start by calculating what their compensation would have continued to be had this incident not occurred. And that's really our starting point. And my job really ultimately is to provide a framework for the jury to use, because the jury is the one that will ultimately determine the economic damages, but they have to have a good understanding of what this person's compensation would have continued to be had they not been fired, demoted, and so on. Our role is to really teach the jury what is necessary to make the plaintiff whole, so that they really should be left, the plaintiff, in the same position they would have been in had this bad act not happened. Had they not been fired, how much money would they have continued to earn? And then they're entitled, obviously, to receive that money so that they can be made whole and left really in the same position that they were in before the bad act happened.
And we are talking about plaintiffs right now, the people who bring the lawsuit, as a result of being wronged by their employer. But your job doesn't stop there. It's not just restricted to economic expert advice on behalf of plaintiffs, is it?
No, we actually work with defense attorneys very often as well. And I think what's interesting to consider is that if, for example, a plaintiff was wrongfully terminated, and if the jury concludes that a plaintiff was wrongfully terminated, in other words, if the jury concludes that the defendants are liable for the bad act, the calculation of economic damages is no different. If you have an individual who was fired, my job is to simply calculate what he would have continued to earn going into the future. And that's independent of any sort of liability issue there. So it's also, it can be very helpful for defense attorneys to have an understanding of what the damages are so that they have some sense, if they lose on liability, what kind of exposure are they facing? That obviously ultimately rests with the jury. But my job really is to make sure that the jury understands what the damages will be, assuming, of course, that they find liability. And I think that information is useful information both for plaintiffs' attorneys and defense attorneys.
We hear the use of theoretical and empirical studies, right, Phil? Making reasonable assumptions. What else? I don't know. Avoiding speculation and assessing economic damages. I mean, that's all really important. Can you help us to understand those concepts and how they apply in an employment law case?
I think one of the things that really is important to remember, again, it is my role as the economic expert. And when we talk about offering an opinion to a reasonable degree of economic certainty or making reasonable assumptions, we're talking about economic assumptions there. We're really talking about, for example, my opinions regarding what the inflation rate is going to be going forward, my opinion regarding what the interest rates are going to be like going forward. I do assume liability because, again, my job is to simply calculate what the damages are and what they will be, assuming liability.
Now, Chris, they're all really good points, and we're kind of like to the end point where you're giving your opinion that we're making this plaintiff whole by X dollars. So if we or another firm were to hire you to assess our client's economic damages, what particular process is in place with your company to start?
The first thing we do is, we'll need to have a basic understanding, obviously, about the case, the claims of the case, a basic understanding of the type of employment the plaintiff had, and so on. And really, our starting point is going to be to review, some documents. I'll certainly want to look at the complaint again, so I have a basic understanding of the case. I may want to look at answers to interrogatories. I will probably want to look at some documentation of a plaintiff's earnings, and those documents may be tax returns or W-2 wage and tax statements or pay stubs. And once I've reviewed that basic information and begun to get a sense of what the case is about, then the second part of the process will be to conduct economic research. I will then be able to determine if I'm working, for example, on a case involving a police officer in the state of New Jersey. Then I will know that I'm going to need to take a look at, for example, the most current guidebook for the police and firemen's retirement system in the state of New Jersey. I may want to request a collective bargaining agreement in that case so that I can then take a look at some additional information that would have an impact on that person's compensation. And then once we've really done those two things, reviewed documents, gotten some information specifically about the plaintiff, and conducted our economic research, we'll then have everything we need to actually calculate the economic damages and arrive at a figure that would make the plaintiff whole.
Now, are you meeting with the client as well?
That's not always necessary. Sometimes we do, and sometimes it's not necessary. Oftentimes in employment matters, our analysis of economic damages is limited, for lack of any better phrase, to calculations of compensation. And this is what makes the work I do in employment-related matters different from the work I do in a matter involving, for example, wrongful death, where I'm going to need to have an understanding of the household chores and maintenance and so on that somebody was doing. So in employment-related matters, because my focus is primarily on compensation, it oftentimes isn't necessary for me to meet with the plaintiffs because I will have independent, objective documentation of what they had been earning and what they likely would have earned going forward. Some cases are a little bit more complex, obviously, and I may need to meet with the clients. But as I said, more often than not, that's generally not necessary for me to do in employment-related matters.
Yeah, that makes sense. I totally understand that. Here's something that we have a difficult time with explaining to our clients, or they don't want to believe us. I'm not sure, but that's oftentimes it's very helpful to have the economic expert, the person, the expert, explain this concept. Discounting for present day value, that concept.
Sure. When I calculate the economic damages in an employment-related matter in New Jersey, I ultimately calculate really a single figure. I end up with one single figure, really a lump sum amount of money that should make the plaintiff whole, that would make the plaintiff whole. So that's a lump sum of money that, assuming the jury finds in favor of the plaintiff, a lump sum of money that the plaintiff should receive and would need to receive today to make himself whole. The concept of present value really takes into account the following. Suppose we had a plaintiff who was making $50,000 a year, and he's wrongfully terminated, and he would have worked for another 10 years had he not been wrongfully terminated. And for purposes of this discussion, we'll assume he's not working, he's tried to find a job, hasn't been able to find a job. Had he not been terminated, setting aside effects of inflation, he would have earned $50,000 a year for a 10-year period, or a total of $500,000 over this 10-year period. Now, oftentimes, of course, plaintiffs and even attorneys will say, great, the economic damages, the lump sum award should be $500,000.
Right.
Problem is, though, as I explained to juries, if in that case I recommended that the plaintiff receive $500,000, I would be overcompensating the plaintiff. And the reason is that the plaintiff is going to get that lump sum award, all of it, today. And he or she is going to have the ability to take all of that money today. Remember, he wouldn't have had that money, all of it today, because he would have earned $50,000 a year each year over a 10-year period. But now you get all $500,000 today. And that means as a plaintiff, you have the ability to take that money today and invest it. And you could put it in the bank as an example and earn at least a little bit of interest. You can put it in safe fixed income securities and earn 2-3% a year over the next 10 years. So if you got all $500,000 today, invested it in a safe fixed income security, 10 years from now, you'd have more money than you would have earned if you hadn't been terminated. You'd be overcompensated. So my job really is to determine the amount of money the plaintiff would need to get today so that he could take that money, invest it in a safe fixed income security. It's going to grow year over year so that each year, at the end of year 1, 2, 3, 4, he can take out an amount of money exactly equal to what he would have earned. So he could take out $50,000 each year over that 10-year period. So when I'm asked about present value, I explained to a jury, in order for a plaintiff to be made whole in this example, he would need something less than $500,000, because whatever he gets today is going to grow over time. The question, of course, is how much less than $500,000 would the plaintiff need to receive today? And the general answer is that's going to depend on what we expect interest rates to do over the next 10-year period. If interest rates are low, as they have been for many years now, that means the money's not going to grow very much over a 10-year period. And the plaintiff's going to need to get most of that $500,000 today. This is going to grow very slowly. If interest rates were 10, 12, 15% a year, which they haven't been for decades, but if they were, then the plaintiff would need a slower amount of money today, because that money would grow rapidly year over year.
I may be jumping, around a little bit, but what are catch-up earnings? Is that not Heinz 57? I mean, like, to catch up. What is that?
When people talk about catch-up earnings, really what they're talking about is they're talking about whether a plaintiff, it's sort of related to the concept of mitigation. The idea is, does a plaintiff have the ability to, quote, catch up? So again, for example, if a plaintiff was earning $50,000 a year before he or she was wrongfully terminated, and maybe now the plaintiff is earning $20,000 a year. So the plaintiff went out and was able to get another job, just not a job that paid what he or she had previously been earning. So the plaintiff's earning $20,000 a year now. One of the questions that often comes up, and it's really sort of outside my area of expertise, but it's still a question that comes up frequently, is does this plaintiff have the ability to catch up? Should this plaintiff be able to catch up? And if so, how long will it take this plaintiff to catch up? So if the plaintiff is currently earning $20,000 a year, is it reasonable to assume that that plaintiff is always going to earn $20,000 a year and really never catch up and get back to the $50,000 a year that he was earning before the incident? Or is it reasonable to assume that that plaintiff will catch up? And if so, will it take him 2 years, 5 years, 10 years to go from the $20,000 he's earning now back to the $50,000 that he was earning previously? And that's really a question that ultimately the jury is going to answer. But what we do to hopefully assist the jury is provide what we call, here's a techie term, cumulative loss figures. So we understand that the jury is ultimately going to have to decide, will this plaintiff catch up? And if so, when? And we want to make sure that if the jury does conclude that somebody will never catch up, they know what the economic damages should be in that case. We also want to make sure, though, that it's easy for the jury to determine what the economic damages should be if the jury ultimately concludes that within 5 years, this plaintiff should be able to catch up or likely will catch up. So we actually have a separate kind of column of numbers there to make it very easy for the jury to determine what the economic damages should be so that they don't have to be doing all kinds of extra calculations on their own.
Now, Chris, I heard a couple concepts, and if we're staying with that example that you used, saying that the plaintiff earned $50,000 in his prior job, and then now is earning 20, are we talking like I've heard back pay and future wage loss, or could you explain that concept and how it ties in to the past back pay and then a future wage loss claim?
Sure. So when we calculate earnings, we do separate our calculations into lost earnings in past years and lost earnings in future years. So what I would do if I was preparing a report today, if this plaintiff had been terminated in 2019 as an example, I would start my calculations in 2019 and calculate what this plaintiff would have earned from 2019 through the present time, through 2022, if he had not been terminated. If he didn't work during that time period, it would be a fairly straightforward analysis of $50,000 a year, setting aside the effects of inflation through the present time. If he had been working, if he had gotten his job earning $20,000 a year in 2020, then I'm going to look at the difference between $50,000 that he would have earned each year through the present time minus the $20,000 that he has earned through the present time. I then continue my calculations into the future going forward, which is frequently referred to by attorneys as the front pay losses there. My job as an economist is not to offer any sort of expert opinion about how long front pay losses likely will last, or how long economic damages will continue into the future. Again, that's a decision that ultimately the jury is going to make. But what I need to do in order to make sure that the jury has all the information they need is to continue my calculations going forward and calculate how much money this plaintiff would have continued to earn had he not been terminated in 2019 and had he continued working from today's date through what we call his statistical date of retirement. So I'm going to present those year-by-year calculations going forward through the plaintiff's statistical date of retirement. And then, as I mentioned a few moments ago, I'll make sure the jury has what they need so that they determine that the front pay or future losses should not go through the plaintiff's statistical date of retirement. They'll be able to adjust their calculations or their decision accordingly.
And that's something that the lawyers would be arguing. Of course, the plaintiff's lawyer has the interest to show the jury that the front pay claim will extend all the way out to the person's work life expectancy, right? And then the defense would be saying things like, well, but they could get another job, and it's not reasonable to assume that, if the work life expectancy is 10 years, it's not reasonable to assume it's going to extend out for 10 years. This person can get another job, and it's 5 years at the most, ladies and gentlemen. But you've done that work. You've done the economic analytical work so that the jury would be able to see the 5-year mark and the 10-year mark, or anywhere in between. That's what you're saying.
Right, exactly. And when I testify in front of a jury, I make it very clear to the jury that is a determination that will ultimately rest with them. I'm not offering an expert opinion about specifically how far into the future the damages or the losses should continue.
And I think two other issues or areas are in play. Offsetting damages and then mitigation of damages. And are they connected? What's the interplay there? And what is your role with respect to each of those concepts?
Yeah, attorneys will very often kind of use the term mitigation and offsetting earnings interchangeably. I don't, economic experts, at least I don't use the term mitigation of damages. And the reason I don't use that term is because that really is a legal term. There are, my understanding is there are sort of legal parameters about how much a plaintiff does or doesn't have to do, and so on. So again, it's not appropriate for an economic expert really to have an opinion about mitigation of damages. Having said that, though, certainly if
Can I
somebody,
interrupt you on purpose there, Kristen?
oh
What
sure,
is, can you just explain for those who may not understand the term, the definition? Can you give us the definition?
sure. Again, from a sort of a non-legal expert here, my understanding is that mitigation of damages really talks about, whether or not, what is a plaintiff doing there? Does a plaintiff have an obligation to try to reduce his or her damages? So again, our plaintiff would have earned $50,000 a year for 10 years. You get your $500,000 without reduction to present value. But, does the plaintiff have an obligation to go get another job? So he hasn't worked for the last 3 years. Does he have an obligation to go get another job, or is he entitled simply to the full $500,000 there? Has the plaintiff, for example, done everything he could have or should have to go get another job? Those are sort of issues that are related to what we typically refer to as sort of mitigation efforts. And as I said, it just isn't appropriate for an economic expert to have an opinion about those sort of mitigation efforts there. That's something that ultimately the jury will consider. The jury will hear testimony from various witnesses, will listen to the attorneys, and really determine, has this plaintiff done everything he can to try to find another job? Is this $20,000 a year he's earning now, has he done his best? Is this the best he's going to be able to do for the next 10 years? Or should he be able to go out and find a job earning $40,000 or $50,000 a year? But those really are all questions that really cannot be and should not be answered by your economic expert, but will be ultimately determined by the jury.
So listening to that, then you wouldn't provide an opinion that the effort that plaintiff imposed was a reasonable effort. You don't get into their job searches, whether they sat at home. That is a different topic that you're not going to discuss as an economic expert.
That's correct. That is well outside the area of expertise of an economic expert. It also really is outside of the role of an economic expert. If I started offering those types of opinions, I really would be usurping the authority of the jury and really stepping on the toes of the jury. They're the ones that will ultimately hear the judge explain to them what the concept of mitigation represents. And they are the ones that will listen to the attorneys make their respective arguments. They'll listen to the plaintiff testify, the defendant. They'll consider obviously all of the facts of the case as well as the whatever instructions are given by the judge, and they'll make that determination about whether the plaintiff could have done more, should have done more, or did everything that he or she needed to do.
Could you maybe talk a little bit about damages in terms of retirement? I know we mentioned like pensions, but how do you calculate that into making a plaintiff whole?
For one thing, I do need to take into account, all of these other benefits like the pension benefits. And, most pension benefits are basically determined by a formula. And usually there's what we call some sort of guidebook or handbook or summary plan description that really tells me how the state of New Jersey or how a person's employer calculates pension benefits there. So I'm able to look at that, and usually pension benefits are a function of the number of years that someone spends in a particular job or the number of hours they work every year. Pension benefits are also typically a function of what we call a person's final average salary. So how much you're earning right around the time you retire, how many years you have worked at that point, and we use that information to calculate the pension benefits. One of the reasons I think it's very, very important for us to consider pension benefits is because, if we have an individual, we have a plaintiff who was working as a police officer in the state of New Jersey and is wrongfully terminated. Well, he loses his earnings as a police officer. He also loses his pension benefits. If he was making $50,000 a year as a police officer, Maybe he goes out into the private sector now and he gets another $50,000 a year job. So it may be very easy in that example to say, oh, there are no damages. All right, he's quote unquote mitigated his damages. He was earning $50,000 as a police officer. He found a job in the private sector earning $50,000. He's been made whole. Problem is, in that example, what he doesn't have in his private sector job is he no longer has the state health insurance benefits, and he no longer has access to the state pension benefits there. So that's a situation in which there likely would be economic damages, economic losses in that case, even though if you do a very superficial look at the salaries, it appears as if there are no damages, as if the plaintiff's been made whole. So those benefits are critical. We want to make sure that we take them into account when we're calculating the economic damages.
In a lot of our cases, quite a number of our cases, we're representing law enforcement officers. And the issue isn't termination from employment. The issue is failure to promote over a course of years. And we're finding that it becomes a complicated economic analysis because of the retirement benefits. For instance, if the officer claims that should have been promoted to one rank at a certain year and was bypassed, and then another year she claims that an opportunity to have been promoted again to a higher rank, she would have been able to apply or have that opportunity available to her, but for the fact that she wasn't promoted the first time, so she's missing out on a two-step rank system, and so she's missing out on those. If she retires, at a certain age, then she's missed out on the ability to have secured retirement benefits, not only at the first missed opportunity, but the second missed opportunity. You understand that example?
Yes, and we work on a lot of cases involving, failure to promote, and specifically for police officers there. And you're absolutely right, because in that example, if the claim really is that you have a patrolman, and the claim is that she should have been promoted to sergeant within X number of years, and also likely would have been promoted to lieutenant. Well, in that example, then, you have an individual who will likely, assuming she's still working, will likely retire after 20, 25, 30 years of service, but is going to retire as a patrolman with a patrolman's salary. Had the bad acts not occurred, she also would have put in her 20, 25, 30 years of service. So that part of the equation doesn't change, but she would have retired, of course, with lieutenant salary in that case. So she would have started collecting higher pension benefits, even though she put in the same number of years of service, but she certainly would have collected higher pension benefits because she would have retired with a higher final average salary. So that's a great example of how even if somebody continues to work, if there are these claims of either a failure to promote or in some cases a demotion, how that will have an impact not only on earnings, but again, on those pension benefits, even though the person is still in the retirement system and is still going to get some retirement benefits when she retires.
And I would assume your analysis would include, similar to your other analysis over the work-life expectancy, you provide those economic damages for each of the given years, and then let the jury decide, what they think or what date they think that plaintiff should have retired. You do the same thing here in terms of retirement benefits. That is, you'll provide a breakdown if the person, if you believe that the officer would never have been promoted to the rank of lieutenant, here are the retirement benefits for the rank of sergeant, but here's the retirement benefits that she should have received had she retired at the rank of lieutenant.
Yes, and it will depend a little bit, obviously, on it'll depend a little bit on the unique facts of the case.
Sure.
And how an attorney is positioning the case. And so in some cases, there may be some sort of strong documentation indicating that a promotion to sergeant, there was a very high probability that would have occurred. And in that case, some attorneys may say, look, We just want one calculation of what the economic damages would be, assuming that she would have gone all the way to lieutenant, because we feel we have enough documentation. We don't think there's any question about the fact that she should have been promoted to sergeant and possibly to lieutenant. In other cases, though, attorneys may say, well, we want to leave it up to the jury to decide whether or not she would have gotten that promotion to sergeant. So we'll have one scenario where we calculate the pension benefits and earnings associated with just a single promotion to sergeant. And then we'll present a separate set of calculations that will include what the pension benefits would have been and the lost earnings. Again, having those two steps there, those two promotions. So again, that'll depend a little bit on the unique facts of the case and how attorneys are positioning the case, but we will very often provide those alternative scenarios so the jury does, again, to make it easy for them to decide what the economic damages should be, depending on how many, in that example, promotions they determine the plaintiff would have in fact received.
How about like a concept of, if somebody's retaliated against, for instance, they work either for the state police or a large company, and part of that retaliation is they force them and they relocate them quite a distance from their home. So before, they really didn't have like commuting expenses and the price of gas now. Are they compensable as part of your calculation if somebody's forced to, let's say, relocate an hour or two from their residence?
Yes, I mean, we would certainly take that into account in our analysis in various ways. So for one thing, we do include in our analyses what we call job-related expenses. So to the extent that we all have expenses related to getting to and from the office, we may buy, I like my iced tea, I buy an iced tea on the way in. In some cases, people have union dues, so we do take that into account. And certainly if somebody now has taken a job a considerable distance away, their job-related expenses are going to be much higher now. There may be tolls, there may be additional transportation expenses. And we worked on one case several years ago that was very interesting because the plaintiff had been terminated from one job here in New Jersey and ultimately took another job that was in another state. I believe it was in Connecticut. And the distance was so great between his job in Connecticut and his home in New Jersey that he actually stayed in Connecticut. He rented a room in Connecticut Monday through Friday. In that example, not only did we have those additional expenses there, but we actually also included, rather unusual in employment-related matters, but we actually included a loss of what we call household services, because when he had been home Monday through Friday, he'd come home after work, he would empty the garbage, he would walk the dogs, he would help the kids with their homework. Before he went to work in the morning, he would drive the kids to school. Now that he's staying in Connecticut, renting a room in Connecticut, he was not available to do any of those household services. So we certainly will take those types of things into account.
And I've had people say to me that because they've lost their job, they don't have an income. They've had to remortgage or refinance their mortgage. Is that something that you as an economic expert would factor?
Yes, so we've had situations where individuals have said they either had to refinance a mortgage or they had to take money out of their 401k plan, for example. That's something that frequently comes up. I had to take money out early. In those cases, though, I think it's important for everyone to remember that if, for example, our plaintiff takes $50,000 out of his 401k plan because he's not getting his $50,000 salary here, my analysis, my economic damages calculation is going to include the $50,000 salary. So if the jury grants him an award, the $50,000 he took out of his 401k plan is going to be replaced. Having said that, though, if he incurred any sort of penalty for withdrawing the money early, that's certainly an expense now that he would not have incurred but for the bad acts. And also, you can make the argument too that by taking the money out of the 401k plan, he lost the ability to accrue some sort of interest or some sort of rate of return. We have to have a discussion about whether or not that's something that makes sense to include in our calculations, because there is something called prejudgment interest that sort of gets at that a little bit. But those are at least two ways in which the lack of income will sometimes have an impact on a person's cash flow. And those are some of the ways in which we can include at least some of that impact in our calculation of economic damages.
But if you could summarize for us the idea of tax consequences on damages awards, because we are required as attorneys to hire an expert if we make a claim on behalf of our client for the tax consequences that are going to be associated with an award of economic damages in an employment case. It's not like a personal injury case,
right,
where those damages, the judgment or the monies that they receive, the personal injury victims, are not taxable.
Right.
But they are in employment cases, right?
They are, yes. And that's something that definitely must be taken into account to make a plaintiff whole. So from an economic perspective, that what we call either a tax gross up or compensation for excess taxes, from an economic perspective, that must be included in any sort of comprehensive assessment of economic damages, because without it, a plaintiff will not be made whole. And basically what happens in employment-related matters is, back to our plaintiff who's making $50,000 a year, if he receives a lump sum amount of $500,000 to quote-unquote replace 10 years of earnings at $50,000 a year, he's going to be pushed into a higher tax bracket. He's going to get $500,000 this year. If the bad act hadn't happened, if he hadn't been terminated, he would have gotten $50,000 a year this year, and then $50,000 a year next year, and so on. And just to give you a very, very simplistic hypothetical example, if he had continued to work and earned $50,000 a year, perhaps he would have paid 10% in taxes each year. So he pays $5,000 in taxes for a 10-year period. He's going to pay, in this case, a total of $50,000 in taxes. If he gets all 10 years worth of income in one lump sum, he gets $500,000 this year, he may be pushed into, to keep the math simple, a 20% tax bracket now. Probably higher, but now he pays 20%. So now he's going to pay a total of $100,000 in taxes. If he had just continued to work and not gotten fired, $50,000 a year, 10%, $5,000 a year. So he would have paid only a total of $50,000 in taxes over his working lifetime, instead of paying $100,000 in taxes this year on that lump sum amount. So he basically will end up paying $50,000 more in taxes than he would have paid had he not been terminated and had he just simply continued to work each year. So without that extra $50,000 in taxes, the plaintiff is going to be made worse off. He won't be made whole because he's now paying a greater amount of taxes than he would have been but for the bad act. So that's really a critical component that does need to be assessed and analyzed in employment-related matters.
There's one myth about your industry or profession. What would you tell us to kind of debunk that?
I think really the one myth that I think we need to debunk is that economists, it's all speculation. It's all assuming. I always love kind of the old joke, the old question. You get 1,000 economists in the room, you get 1,000 different answers. That's really not true. I do a lot of defense work, so I review the work of many other economic experts, and most economic experts are using very similar methodology there. We may arrive at slightly different conclusions there. And I suppose the only other thing, since you asked the question, the only other thing that I would mention is that it's important for people to note that what makes an economic expert, I think an economic expert, is that individual typically has years of training and education and experience really in the field of economics. And I know for me, one of my great frustrations is always to turn on the news, and it doesn't matter what channel it is at all, and to see somebody on there purporting to be an economist. So I think there's kind of a general, in the general society, I think that many people have assigned the title of economist to individuals that may be very qualified to do many things, but who really don't have a background in economics. So make sure when you are working with an economic expert that they are well-rounded in the discipline of economics.